Great. Well, thanks for having me as part of your session. I'm sorry that I couldn't fly over and be there. I have to gently give Simon a hard time, though, because when he rescheduled me for today, it's a holiday here in the United States. It's Labor Day, and I don't know whether Ed Miliband and your Labor Party would approve my doing this session, but be that as it may, I'm happy to be here, and maybe it can be in person in some future year. Simon was quite right that I'm a lawyer, and lawyers don't really know very much about visual analytics. We're going to just sort of step into the waters a little bit here in this session. But what I really want to do is, let me see if I can do this with this screen here. As an overview for today, I promise that I will get into visual analytics, but I want to set this up in the right way. And Simon's heard this, or portions of it before, but I think it's good to have sort of a common baseline as to why lawyers would benefit from visual analytics. And to really get a sense of that, you have to understand how poorly lawyers perform in doing their job function when they are faced with electronic records and electronically stored information, or ESI. And so I want to talk about e-discovery and e-disclosure just for a moment here, and I'm going to do it on this slide, and that's it. And then I want to go into a more extended conversation about what I call the as-is model of performing searches for electronic evidence, searches for electronic information that would be of benefit to litigation. And then you'll see that in my own life case example of in the tobacco litigation, U.S. versus Philip Morris, what the limitations were. But I want to move beyond Boolean and explain what's happened actually in the last year in the United States with some new landmark precedent by a federal judge that actually sets up this problem in really a good way, some would say in a cool way, to in terms of the problem for lawyers as to how to optimize or leverage new methods. And then we will ease into a set of nice-looking slides on sort of visual analytics, and I promise we'll get there as our ultimate goal. I want to spend 1 second here on e-discovery and e-disclosure. As far as I'm concerned, for purposes of this talk here today, we say electronic discovery or e-discovery in the United States, in the UK, and in some other countries, there's e-disclosure. It's the same thing. It's the fact that we're not in the paper document business anymore. When you are in civil court, when you're in litigation, whether it's the United States or in other countries, increasingly lawyers on both sides are going to present evidence in the form of emails and electronic spreadsheets and anything that you create on the desktop, and ask that they be retrieved from the other side in their electronic format so they can be manipulated and searched in some way that you can't do with paper documents. So we moved very quickly, very rapidly in the United States from 10 years ago, where most lawyers are worrying about paper and documents, into this world of electronically stored information. It was codified in 2006 in the US, and it's Part 31 of the UK Code. But it's the same thing on both sides of the Atlantic. It's the fact that lawyers increasingly rely on electronic stuff, but they do so in very, very old-fashioned ways. And so let me go on. I can't help. I mean, maybe I can see. Maybe I'll test this video screen here. See how many people in the room have been to Prague. Been to Prague? Raise your hand. I see 1, 2, 3, 4, whatever. It's my favorite city, and you really all should put it on your life list. If there's one takeaway from the summer school, is go to Prague. It's just beautiful. And of course, as I work in the federal bureaucracy in the United States, Franz Kafka is my patron saint. And so that's partially why I like Prague. This is a shot of the castle from the Charles Bridge. And the reason I put it up in my talks is that it's a metaphor It's a metaphor for, the castle is a metaphor for the difficulties in searching. If you're in a castle, you have hundreds of rooms that are unknown to you, passageways, secret alleys, whatever. And think about federated searching across the enterprise. Think about the ways in which we try to get at various, whether it's emails or other documents, on various legacy platforms. It's a difficult, difficult task. It's difficult to know all the rooms in a castle, and the rooms in a corporation are very similar in terms of the task at hand for searching. So that's a threshold issue that lawyers need to confront. But even when they're in a room that's well known to them and they have all the documents in the room in electronic form on one server or one shared platform, it's extremely difficult to do searches. So another metaphor is searching the haystack, and the task at hand to find relevant needles ends up like searching in a maze. And so I'm not sure why that didn't work. Let's see if that, no, it didn't. That's funny that the pictures aren't coming through. So let's see if this is, you have a PowerPoint issue on your end, which I'm seeing. Do you see that, Simon?
We're seeing a slide without much content on it.
Right. You need to reload the slides, I think.
Yeah. Just give me. Okay.
Otherwise, we're going to have a blank, a very blank talk. Although I could do this without the slides. But shall I just keep going while you're working on it?
Just give us a moment there, Jason.
Okay.
There we go.
Is it a flash issue? Perhaps we can run them from this end. Aha.
Aha. Okay.
I think he has. Do you have animation on there? Oh, no? Okay.
I have a couple of clicks on a slide, but you can keep going past that. The problem is what else is there? You might want to. Okay, keep going. All right, why don't we stay with that, and we'll see what works. Can you hear me?
Yes.
Okay, good. So email is the 800-pound gorilla here. What I was going to say in the other slides about the haystack and the needles and the maze is that when we as lawyers want to do searching, it's a very different search task than what you might think of as on Google or on your favorite search engine box. If you want a restaurant in London tonight, you type in restaurant London, you get a bunch of hits. You don't look at hundreds or thousands of pages. You concentrate on the first few pages. But lawyers in the UK and the United States, when we have a task, an information retrieval task, which is please find all documents on topic X. That's the basic plain vanilla task we have. And the problem is that we need to find all of them or do a reasonable job in finding all of them. And a lot of them are on email. And so it's a long tail, and it's a different task in terms of what constitutes reasonableness. And that led to lots of research, which is going to be a little off topic for today. This slide that I just put up there is to show that we really are talking about large collections of data. So if you can imagine, no one possibly has the time to page through or even after keyword searching to look through 350 billion pages in a typical investigation. And you can use Boolean searches like were done in the Lehman Brothers investigation about a Wall Street collapse firm. But the fact is that visual analytics offers a promise to do something different in the space when you're faced with these large universes that we're all confronting. So it's not just a few thousand documents or a few million, it's billions or trillions. And that's a different world going into the future. And that's why it's so exciting to have the possibility of doing visual looks at a collection as just a helpful exercise. Now, my experience in this area starts really where I was tasked, as Simon says, I'm a lawyer for the National Archives, and we inherit former presidents' documents, including emails. So we inherited 32 million from President Clinton, 2001, when he left office. And there was this big lawsuit that looked back 50 years. The United States sued the big tobacco companies, and that lawsuit is still going on. And it had 1,000 or more requests to produce, 1,700. The lawsuit involves the conspiracy allegations going back to 1953. So the documents go back to the 1950s, and we had to search paper documents as well as electronic documents at the National Archives. But just imagine what you would do here, just for a moment. Close your eyes. I can't see your eyes on the screen, so you can I'll just indulge you. So the fact is that if you just imagine somebody asking you, okay, how would you go search a collection of 32 million emails? And the answer that I had was that I came up with keywords, did some informal negotiations with the other side, sampled for noisy terms that were generating too many false positives. I'll get to that in a moment. And then reported back on the search protocol. This was sort of an early look back in 2002, 2003 of what is more routinely done today. The keywords that I used on the left, I dreamed up at my desk. Now, I've been lecturing about this, that there are better ways to do keyword searching than what I did. But you just dream up keywords and then have some negotiations over some keywords that produce false positives, like Philip Morris Institute, which I'll say in a moment. So here's my problem. Al Gore started this lawsuit. He recommended to Bill Clinton. There were a lot of White House emails that involve Al Gore. The other side was looking for emails that were about Marlboro, the Marlboro Man, and what the White House was saying. But I kept running into Julie Andrews, and I'll explain why in a moment. So the suppression of false positives is one giant limitation. The need to suppress false positives is one of the biggest problems with keyword searching and looking for alternatives. Because instead of finding emails on Marlboro, we get a town named Upper Marlboro, Maryland. Instead of finding emails on Philip Morris Institute, kept running into emails about the Presidential Management Intern Program. And if you can just imagine emails about Monica Lewinsky, there we are. So, who I note is a graduate of the London School of Economics. In any event, I digress. So, a master settlement agreement. Medical savings accounts, metropolitan standard area. Any term that you can use on keyword searching produces false positives. And my favorite is that while the tobacco companies wanted me to search against the term Tobacco Institute, TI, the only emails that came up with TI in the string were emails about the Sound of Music and Julie Andrews and Del Re Mi Fa Sol La. So there you have it. And I knew then that keyword searching was tremendously inefficient. I came up with these Booleans. This is what lawyers have been doing for the last decade. Keyword searching is a Boolean string with ors and ands and nots. But you get some relevant documents, but you get a tremendous amount of irrelevant documents, non-responsive documents, and you miss documents. And so that is the real limitation of keyword searching. You can do a sophisticated Boolean, but you're not getting a good picture of the entire collection. And I vowed then that I would go and find the best people around the world to help me thinking about advanced search, and put on workshops. And Simon came to a workshop, and I learned about sense making. And so here we are. So my task back then was 20 million of the 32 million I actually searched myself on a front end with the keyword searching. We are the National Archives. We're looking for tobacco policy. I hired 25 archivists and lawyers for 6 months to go through the hits, the keywords that we found of the 20 million, to have 200,000 documents, and then separated out 100,000 relevant ones from 100,000 irrelevant, and then we coded 20,000 as privileged. This took 6 months, and it's impossible to replicate today with 1 billion emails coming from the Obama administration or whomever is in office in 2017. just can't do it. It doesn't scale up. And over the next decade, with exponential growth in electronically stored information, we're going to have, the paradigm is broken, and we're going to have to think of new methods to go about our business. And luckily, there have been, and there are two very, very promising paths forward. But just imagine if we really had 1 billion emails, and we really had to go through them, and we reviewed at 50 an hour using just traditional methods, it would take 54 years to complete using 100 people. That's clearly beyond the pale. We can't do that as a legal profession, nor, shall I add, can historians or researchers of any social science discipline depend any more reliably on keyword search and paging through millions and millions of documents. Every discipline that you can imagine would benefit from more advanced search techniques and visual analytics. The judges in the United States understand this. They have been writing opinions in the last 4 years. Here's Judge Grimm saying that universally acknowledged that keyword searches are useful, but growing literature that says they're unreliable or inadequate. And they cited to a commentary I'm associated with in the Trek research project. Another judge in the United States saying, hey, look, the whole subject of keywords is very difficult and deals with computer technology, statistics, linguistics. You can't possibly get it right. It's to go where angels fear to tread. He was imploring the parties in that case to think about new ways. Back then in 2008, he called it concept search. We're going to talk about predictive coding in a moment. Now, I promise the next 3 slides are heavy going, or the 2 after this. I'm going to go quickly because this lecture is not an information retrieval lecture about vector space stuff. But just, this is from Ellen Voorhees, who leads the NIST project, National Institutes of Standards and Technology Trek project, for the last 20 years. She's talking about Boolean retrieval as having pros and cons. That it's very good transparency, you know what you get. Instead of looking at a picture with a cluster and not really understanding it, you know what you got when you have keywords. The problem is that there's little control over the set size. There's no ranking of what the most important documents were. You can't see the relationships between documents very well, and other problems. Now, this is heavy going, and I'm not going to pretend that I know anything about this in terms of an information retrieval scientist. My PhD friends at the University of Maryland could lecture at great length about vector space models. But the point is that there's a range of techniques that I'm sure many in the room are aware of that rely on latent semantic indexing and other forms of vector space modeling that basically cluster together documents based on how similar they are by looking at every word in the document, and that the number of terms in the document set in this n-dimensional space is really the number of different words there are, and seeing similarity, matching together documents that really are very much alike. Think of an email thread of mere dupes. Think of it as documents that are all on a particular topic. And in doing so, this really does turbocharge document review in ways that I'll get into if you're using these kind of models. So again, I'm not going to spend more than 30 seconds on this slide, but the point here is that there's an underlying mathematics and there's an underlying information retrieval theory to document clustering that is well worth understanding if you're going to be the most useful people in terms of doing visual analytics. It would be, for the legal space, it would be good to know something about underlying information retrieval concepts like this for going forward purposes. You don't have to know it in all instances, but you would be absolutely of the most use to lawyers in the profession for knowing something about clustering and how it's built. So there we are. And the point is that if you take clustering methods of putting like documents together, then you basically speed up the document review process. Instead of taking years and years or months and months, it will take less time, dramatically less time, because what lawyers can do is say, oh, this entire cluster of documents is about a particular topic. It may be a topic that, corporation that's just, something about fantasy football or soccer or whatever, and everybody's talking about it and has no relevance to anything. So you take thousands of documents off the table by clustering them and putting them to the side. So you have basically black lists using clusters as well as white lists. In addition, the emergence in the last year, big time, of something called predictive analytics, predictive coding and supervised learning, is going to change the landscape of lawyering, because in addition to the clustering algorithms, what is increasingly expected of lawyers is to sit down with the other side and come up with a protocol for sampling and for iteration based on a seed set. And the seed set is developed in various ways, but essentially a process where you code a small set of documents in a large universe and call them relevant or not relevant, and then let the software, the predictive coding algorithms, code the rest of the billion documents so that you have, across the entire space, a means to at least a first-order approximation of what might be relevant or not relevant, but then you do quality control checking. And this method of both seeding a data set as well as using clustering techniques has been advanced in the last couple of years and has found its very first judicial opinion in the United States by Judge Peck, writing in the Southern District of New York in February of this year, where he says this opinion is the first which has approved this kind of method of computer-assisted review. And lawyers should consider this tool. He says at the bottom there, counsel no longer have to worry about being the first or a guinea pig in terms of a judicial acceptance of computer-assisted review. It can be now considered judicially approved. Well, that's a little bit of a grandiose statement because he's only one judge, and there are hundreds and hundreds of judges across the United States in federal court and thousands in state court. But he is a leading judge, a thought leader in the space, and people respect Judge Peck. And certainly in his courtroom, that this is now true, that he would expect lawyers to be engaged in a protocol where they're using these clustering methods, iteration, and sampling. And so I urge anybody who's really interested in this to follow up with me or with Simon. I can get you the sites there. I think there are references at the end to a very detailed protocol that you'll easily see can be translated in terms of a visual exercise, in terms of clustering documents. And so, and I'll make mention of it in a moment when we get to the pretty pictures. So this is the state of the art in the United States of where lawyers are expected to go in certain courts. Now, keyword searching is still as is. This is sort of the moment here of using supervised learning, machine learning, predictive coding methods. And then the question is, what is the world of tomorrow? Now, the world of tomorrow is the world of visual analytics used at every stage of the e-discovery process. So I'm personally excited that I'm invited to talk in this lecture here, that you all are able potentially to change the legal world in the UK. Anyway, I absolutely believe this with all my heart, that if that the people that are at the summer school here, if you take this lecture to heart, and if you want a job where you're using visual analytics, you should align yourself, you should find a way in to corporations and to law firms that are looking for people of talent who know something about e-discovery and can apply all the techniques you're learning this week. I absolutely guarantee in the United States that people who are coming out of schools of information studies, who take an e-discovery course have a leg up in the job market. And I really believe it. I mean, I think it's just fun doing all this, but there's actually a concrete reason to do it as well for your career. So I urge people along and happy to talk to people offline about it. So what's the world of tomorrow? Okay, so some of these examples and the ones that follow are from my good friend Vicky Lemieux at the University of British Columbia, who's done a good article on visual analytics and has been a leader. Jeffrey Yao, that Simon knows, is someone at UCL who cares about this subject, and there are others that, throughout the United States, and the UK, and elsewhere that are increasingly focused on the legal intersection between how visual analytics can help. And so here we go. So this is a diagram for Vicky. It doesn't matter what the attributes are. The point is that the clusters that you're seeing, a three-dimensional clustering, is exactly what I'm talking about in terms of predictive coding, supervised learning. If the results of that process of putting like documents together result in clusters, then you can zoom in on a cluster and look to see its relevance and its connections in a space with others. So it's more than just a pretty picture. You can actually take one of these three-dimensional hilly areas and colored areas and zoom in and have, in a holistic way, a better understanding of a set of documents that the software is saying are very much alike, and then move a cluster to the side once you've done it. There are tools that allow that. So that's one way in, and let me go to the next. This is a galaxy view. It says British Cabinet Papers. I didn't research this, but and it may be a little difficult to see, but I think it's coming from World War II and looking at French and German ammunitions and various ships and staff. And each galaxy view is essentially a cluster of documents, which, again, have been teased out as being similar together because they've been coded as similar. Again, going back, the absolute optimum way to approach the visual side of it is to have humans code a seed set and then let the software do this kind of rollout of a galaxy view based on the coding that the software does, looking at vector space similarities between all the other documents in a set with what you code. Obviously, the right question to ask here is, well, how can you trust the coding that started? You have to leverage a lot that's going on based on that coding. So it's very important that's why the lawyers getting together and under a protocol negotiating what constitutes a seed set. If you just have one side in the litigation doing this, they may have a very biased approach or an under-inclusive or over-inclusive approach. Whereas if you get both sides together, you're trusting that process of getting lawyers together negotiating over a seed set will get the coding right, and then that will lead to the predictive algorithms working, and that you'll have a basis for looking at clusters of documents in this way. So to me, this is very exciting. This is what lawyers should be looking at when they're loading 1 billion documents on a platform. Forget about keywords. That's the way we've done things for the last 20 years. And forget about looking at hard copy documents, except in just a very few. Let's look at pictures like this and try to work from them. So I'm going to have a series of other examples here. They're all of a various type. This is a river view showing data changes over time. It wasn't developed for e-discovery, but I can appropriate it. And I've appropriated a number of slides that have nothing to do with e-discovery. They're just sort of out there as visual depictions of what can be done with graphs and charts and databases of various kind. And so this shows the kind of thing what can be done, which is that if you're taking a look at a collection over time, you can look at words or phrases or concepts and see how they they represent kind of cultural themes or memes within an email space or within a document collection. And so colors here are word frequency, but you can easily apply this to any discovery problem. Bar charts are very important as a function of time and organized in any way that you want, by authors talking, by a number of topics, by keywords or whatever way you want. And so this is a very useful device that should be used as part of any litigation when looking at a collection and asking what the attributes are and then making a visual analog. Here you have everything coming from a particular person whose name I believe, it's hard in my screen to see it, but Tim Belden in the middle. All the lines are showing the organizations that he's associated with, that he's emailed. This is from, I believe, the Enron collection and of emails and that's on the web. And then that's organizations on the left, and on the right, locations of where he's talking to around the world. But you can develop any kind of grid or axes, that whatever attributes you want to make the left hand and the right hand side from any individual that's in the space in the middle. Extremely useful to see in an instant the kind of connections to this particular individual, Tim Belden. And so it's an excellent way of proceeding to look at sort of an early case assessment of where you are in e-discovery and to understand what your collection has. And it's also a way to evaluate what you get in terms of a data dump from the other side. Okay. Now, one other whole range of uses is a link analysis or social networking, social graphing, to show who is talking to whom in an organization. And it is extremely useful and sometimes surprising to see who is talking to whom. So I don't have a whole lot of slides from. This is also new, that it's not something that we have at the National Archives, and so I've sort of made it up in terms of looking at slides out there. You have to imagine that the nodes here are important individuals within a corporation talking to a variety of their colleagues. And what lawyers will do is exploit the lines and the connections between the nodes and click on them, see who's talking to whom. You can do this in any number of pictorial ways, and you can essentially extend this out. So there are issues of scale in terms of making the links too complicated in terms of scaling out. But I just have a variety of examples here that I'll just click through. I said links of near infinite complexity, but that's probably not true. I mean, in terms of making a whole galaxy out of this, you want to really focus on a particular individual and look at their connections on a smaller scale to who are they talking to, when are they talking, exploiting the metadata connected with the email, the header information in word processing documents, who has been sharing with who, when documents have been created and modified. So it's just that you're looking at different links and concentrating on a message stream between specific individuals more than that galaxy view is a more useful exercise. And when you're taking a deposition, it's useful to have had a knowledge of what individuals have spoken, who they've spoken to in the corporation. And so it leads to the possibility of more insight in terms of cross-examination and testimony in space. So it could be of help. And then I couldn't help myself. I just went into Wikipedia, and this is all about philosophy. And so you can, it's a very pretty picture. You can dial in to connections between all the philosophers that have been mapped in the Wikipedia space, and dialing into various well-known British philosophers and others. So that links are very important as a use. The links in terms of who's communicating with who, extremely underused, underexploited, but it is ripe for people like yourselves to go out and make the business case that this can be used in legal settings to good effect and to inform lawyers. Now, now these are, I think those are the more interesting applications, frankly, and I've tacked on a few other pictures here that show more mundane uses of visual analytics for content analysis, but the sky's the limit. I mean, the fact that I just dreamed up a few slides over the weekend or something, or took them from various sources, doesn't mean that you couldn't create hundreds of different ways of using VA techniques in legal settings. Really, it's the imagination is the only limit. Here, this is from Maria Steva, who is a researcher, a PhD out of UTexas and working at the Texas Advanced Computer Center. She's analyzed in this tree map form essentially every larger rectangle of a certain size is a set of documents on a particular user space, and what she's looking at is the essentially file sizes within a particular user account. And so some files are just, they take up the entire space on a drive or a lot of it, and others less so. But one can drill in, and you can imagine that there are many different ways to take a look at servers that give you a look into what is on the server. Even more mundanely, certainly we're all aware of pie charts and bar charts, but in terms of where messages are coming from, the countries didn't come out on this slide, but it doesn't matter. The point is that in an increasingly global world, UK companies talking to the United States, talking to Europe, talking to other places, if you want to know where the message traffic is, you can take a collection of objects and do a set of metrics that would be very useful to know. So that's where the last slide was, where messages are to and from. This slide is the different types of messages in an online repository. Clearly, there's a whole set of older forms of documents, emails, and word processing and spreadsheets that exist in any legacy collection of a corporation. But if you're looking online, you can certainly do this kind of discrimination. That's fine. What I like about the possibility of, in particular, in using visual analytics is looking at particular spikes in communications between either two units in a corporation or individuals. And so if you are able to do an analysis, if you load in a set of emails and you let the software run so that you're producing these kind of spikes that noticeable differences between, like the general counsel's office and the chief information officer, or whatever, there's some auditor and some individual general counsel. There's a spike noticed. You can concentrate in on the emails or the documents that were created within that particular time period to then ask to cross-examine individuals in litigation. And similarly, spikes in conversations about specific topics could be of evidentiary interest. This is just, I pulled this off that it had nothing to do with e-discovery per se, but it can be applied in exactly the way that I mean here, which is that if you are producing these kind of graphs, you have a basis for then zooming in to focus in or drill down on particular types of conversations that are occurring that wouldn't have necessarily occurred to you before. If you have a bar chart showing two individuals who don't talk very much, but in 1 month, it's 10,000 messages. You wouldn't necessarily know that by keyword searching and by looking at hard copies or by even looking online, clicking through. But the visuals show a different story, that there's something unique going on. And that's of real importance, could be real importance. Here's another conversations on email per hour on topic X. Again, this slide was not originally created for any kind of litigation thing, but I've appropriated for my use here. You can see how easy it is if you're using that kind of the clustering algorithms and the predictive coding to then generate by topic what's going on throughout a collection and then sort it in a time-wise sense. Then you have potential here for insight into matters that you wouldn't normally have. So that's really the end of my visuals. There are challenges in the space here that we all have to realize. The ease of use, well, that will vary depending on how easy, in terms of a human-computer interface, the visuals are. And not everybody is going to be happy with just sitting down at a computer and interacting to get these kind of visuals. We'll need experts like you. Lawyers can't do it themselves. The analytical reasoning techniques, well, and the data input, these are all matters which need to be understood. We need to understand how those pretty pictures are constructed. And it is a little more difficult to explain some of what's going on, certainly with respect to supervised learning and predictive coding and clustering algorithms. As difficult as that table was in terms of vector space and and trying to get through that in terms, talking about cosines and similarities. Just imagine telling a judge who's as old as I am, in their 50s and 60s, whatever, about this stuff, or even lawyers who are older. It's not an easy topic. It's not an easy topic to explain and to defend in an adversary system. And so we have to be very clear as to what we're doing when we're generating these images, and to be able to tell a story about how the software works and what it is that we're actually seeing and what the limitations are. But beyond that, I've said, visual representation, interpretation, to the extent that there are ambiguities in terms of how to interpret clusters, that needs to be explained in a defensible way. Scalability is an issue. I've mentioned the fact that you can't, for a billion objects, it's very difficult to do link analysis, but you have to sort of focus in on particular relationships in a small region of the entire universe. I mentioned tech savviness in my discussion here of lawyers and judges, or the lack thereof, and defending. Simon's heard me say this. That's why I think Simon's work is so important in terms of sense-making and storytelling. There's a natural parallel. When I stand up, I've stood up 100 times in court in my career to try to convince a judge to do something that one party wanted. And in doing so, you have to be credible. You have to stand up, look at the judge, and be able to explain what it is that your client has done. And in my case, explaining where backup tapes were and how they were restored, to make sure that they were stored well and that we didn't miss any, or in the next generation to explain how searches are done using keywords or using other methods. And the judges in the United States some of them are going to challenge you and really cross-examine you in court, a lawyer, about how they did it if they don't know. They need maybe an IT person, an information technology person, or somebody who's going to explain visual analytics in a way that makes sense, and then the judges will accept it. They don't have to know every last bit of computer code, but they need to be able to hear a coherent presentation, a coherent story in court as to how this was put together and built, and then it will make sense to them. A topic that is of interest to me is how we can use visual analytics to change the kind of information retrieval tasks, the kind of questions asked in e-discovery cases. If you remember, what I said is that my task is produce all documents on topic X. That is the standard way that interrogatories and requests to produce are formulated in the United States and in the UK. One lawyer will ask the other side, give me all documents on topic X. But there are many more interesting questions than that, which have never been able to be answered because we don't have the tools to answer them in the law. What was the first time there was a spike in communications on topic X? How many messages were recorded and between whom? Who were the senior-most individuals who knew on a certain date that topic was being discussed? And how did this knowledge spread through the institution? I can imagine sort of flow diagrams and changing colors over time with a topic as it spread through a universe of people. There are lots of ways that could use visual analytics to inform us and to basically change the sophistication of the questions we're asking in litigation. And maybe it's not done in a formal set of documents. Maybe it's done based on your analysis of the data that you've received, and then you can say something in depositions or in testimony, cross-examination. But it's definitely the world of the future, and so it opens up doors for lawyers in what I think are exciting ways. So my last few slides are just some strategic challenges. Convincing the legal community that advanced forms of automated searches are not just desirable but necessary in response to large volumes. Maybe there's a judge out there or even a lawyer who's kind of like been in a cave and doesn't understand that there's a world of petabytes, exabytes of data flowing around the earth, and in particular litigation, there could be terabytes or petabytes. And so they have to get it. That any judge who thinks, oh, you can just read through the documents and figure out what's relevant is yester century, really. It's 20th century thinking. Another challenge is designing a review process which maximizes the potential to find responsive documents no matter what search tools you use, and using sampling and VA techniques to test hypotheses. So this is a challenge in designing these processes. Lawyers are going to get better and better at it with your help. It is clear that supervised learning, the De Silva Moore protocol that the judge is talking about, is the wave of the future, but there's still very little use of visual analytics on a day-to-day basis. And so the most savvy lawyers use it, but they realize that there are challenges. And so we can all have this conversation going forward. Having parties understand that the use of visual analytics does not guarantee that all responsive documents will be identified. This is true of any advanced search technique, any advanced technique using technology. The idea that we're going to find some magic way of teasing out every relevant document in a billion document data set is too much to ask. That's unicorns and rainbows. But nevertheless, it is important to understand that we can do a better job than what we're doing today. We just can't do a perfect job. In the United States, there's lots of legal precedent that you don't have to do a perfect search, just have to do a reasonable search. But sometimes judges pay lip service to that, and they really are expecting that all documents will be found, and they're very annoyed when one isn't. But you will miss documents, even if you're centering in on a cluster, a galaxy view, and you're taking all the documents in the galaxy. It doesn't mean that means every document that's in the larger universe that's relevant is going to be found. And lastly, being open to using new and evolving search information retrieval methods, including VA, based on increasing powerful data mining and AI techniques. It's an exciting time to be in 2012. I absolutely believe that 10 years, 20 years from now, we're going to have much more powerful techniques. There was something that made me sad in the world when Deep Blue beat Garry Kasparov for playing at sort of an international chess levels. There are going to be tremendous gains in AI that will challenge our notions of what it means to think in the future. We're not quite there yet in terms of robots and smart machines, but in terms of using AI techniques to do a better job on very hard problems involving language, well, there are advances going on. The predictive coding, supervised learning methods is one major advance. There'll be others, and it's up to you to help out. Now, I don't know whether you can read this slide, but I can read it, and I'll just say what it is. It's a New Yorker cartoon, which says that I'll be happy to give you innovative thinking. What are the guidelines? The challenge for everyone in the room is to be innovative and not expect that somebody behind a desk knows the answers. People like me are looking to people like you to help us along and to be creative and in the space. And so we can all be on this journey together. References, I do urge people who are interested in this to take a look at Vicky's article with me. It does appear online. You can click on the link, and I hope that the slides, Simon, will be supplied to everybody. And then there's a bunch of other articles in space that you can all take a look at. And I'm happy to entertain cross-Atlantic conversations. Maybe I'll get across the Atlantic one of these days. I'm doing a workshop that Simon knows about next June in Rome that is bringing lawyers and academics together. We had a workshop that Simon was chair of in London in 2008, and we've had a series of workshops in different places around the world to talk about these kind of matters. And maybe we'll throw in some visual analytics as well in future workshops. So thanks very much, everybody, for having me.
Thank you, Jason.